We're starting off with a classic case of when keeping it real goes wrong. This defendant is back in front of the judge for probation violations, and the judge is already losing patience. Legal insight. Probation is a contract with the court. Once you break that contract by missing drug tests or using unprescribed meds, you lose your leverage. This judge isn't interested in blabby blabby blab. She wants compliance. Engagement question. Have you ever seen someone talk their way into a jail cell? Because that's exactly where we're headed.
Like a family friend.
So this,
I wasn't on the property. I was walking back to the property, and the cop and the venue owner had mistaken me for him and told me not to come back.
no, it says, I observed the listed suspect later identified as Jesse Ramos, that's you, right? Walking in the immediate area with a blunt rolled and tucked behind his ear and could smell the odor of intoxicants emanating from him. That's you.
Yeah, but I wasn't smoking. I didn't have nothing on me when they got me.
They said you had a blunt rolled up and tucked behind your ear.
I didn't. I probably smelled like it, but I didn't have nothing on me.
I'm reading with this. This is what you've stipulated to. And then, so there's an altercation where the police are saying, nope, you're not free to leave. They're detaining you. Then some female comes up and they only identified her as your girlfriend, begins to interfere with the detention by pushing herself between officers and attempting to move their hands off of you. So who is this girlfriend?
She was a friend. I don't know why she called herself my girlfriend. Or did that get in the mix.
Oh, so she did that to get in the mix?
I don't know why she did that or not, but
because you told her she was your girlfriend?
She was not my girlfriend. I don't know why she got in though. There was no need to do that.
And then it says a large crowd of family began to approach from our rear area.
That was to try to break everything up.
No, why? There's no need for them to break everything up. They were detaining you. And then the officer says that you put him in a headlock. And then it says a crowd began to wedge themselves between the officer and you. They ordered the crowd to disperse and told them that you were being detained temporarily and not free to leave. Another female, later identified as your mother, Ashley Marie Perez, is that your mom?
Yes, ma'am.
All right. Began to shout back that she would take him home, to which I responded, Ramos was not free to leave. Ultimately, the crowd of individuals guided Ramos beyond my initial ability to pursue. So that's what I'm talking about. Why are you doing this? And how old are you?
I just turned 21 in July.
You just turned 21 and your mom is allowing you to smoke marijuana and have blunts. How far did you go in school?
To sophomore year.
Sophomore of high school?
Yes, ma'am.
And your mom is allowing you to smoke marijuana, be out here at this hour.
That was her wedding night.
And your mom is allowing you to be out here at this hour smoking marijuana and allowing you not to graduate from high school. That's what's wrong with society today. Part of what's wrong with it. Everybody's trying to be somebody's friend instead of being a parent. Why would your mom allow you to be smoking marijuana? Are you going to say everybody at your mom's wedding venue was smoking marijuana? Your mom, I think that's your mom. She's shaking your head and said nobody was doing marijuana at her venue, I guess, except for you.
Off the property, yes, ma'am.
So your mom is allowing you to smoke marijuana. Your mom allowed you to drop out of high school at 10th grade. So do you have a full-time job?
As of right now, yes, ma'am.
Did you have a full-time job then?
In high school, I was working, yes, ma'am. That's the reason why I stopped going.
I don't know why parents are allowing this. So where do you work?
Right now, Taco Cabana. And then I work in a...
Hold on. Did he just say his mom let him smoke marijuana on her wedding night? The judge is absolutely flabbergasted, and honestly, so am I. We've moved past legalities and into a parenting seminar. The judge is highlighting a massive issue here, the friend-parent dynamic, when the people supposed to keep you on the straight and narrow are the ones handing you the lighter. The system has to step in as the parent. This is a rare moment where a judge's personal frustration with society really peeks through.
Have a spot in the company. It's out of town.
What is that?
It's my cousin's. He has a LLCs and businesses.
I don't know what that is, counsel.
I think it is putting those signs for the weekends and then picking them up by Sunday afternoon or late afternoon.
Mhm.
We
Something
like
like
do
that.
remodeling.
And plus remodel.
So have you learned something from this?
Yes, ma'am.
What have you learned?
Not to ever do this again. Put my hands on an officer, get in an altercation.
And let's see how much you've learned. When I drug test you today, what are the results going to be? Because that'll show me if you learned something.
From probably dirty from like the past month because it takes a while to get out of your system.
No, it's this happened on or about November 16, 2024. And if you learned something from that night, you still wouldn't be doing drugs. So are you telling me this is some new form of marijuana that stays in your system like close to a year?
No, he meant to say that he probably smoked like a month ago.
Yeah. So he didn't learn anything from this because a month ago, we're in October. So a month ago, to put us in September of 2025. So you have learned nothing. Who do you live with?
My tia.
All right. So what, your mom put you out or did your mom's new husband put you out?
No, ma'am. I moved over there because it's closer towards the city. She stays more like far west side, Helotes area.
I don't know if he's going to do well on probation. And let me just tell you why. I don't think he's learned anything from that night. He's still doing marijuana. I'm going to follow your agreement. I'm just telling you the tea leaves are saying that he's not going to do well. And his mom is not helping because everybody wants to be everybody's best friend. I don't know what happened. I don't know what's happening at his tia's house. I don't know. Is your tia allowing you to do drugs at her house?
No.
Then where are you doing drugs?
When I have free time.
And where would this be?
3 hours during the day I have to myself when I get away from people.
Yeah, but where are you when you're doing drugs?
Sorry.
See, he needs structure. He doesn't have it. I can't give him structure other than tightening up his conditions of probation, but I don't know if he's going to do well on probation.
We've discussed that, Judge, in my office and the days that we've been in court, and he assures us that he's going to stay away from marijuana because I told him you can't be doing marijuana or any
I
other
can't
kind of.
mess up. Yeah.
I made that abundantly clear, Judge.
Oh,
The tea leaves aren't looking good for our first defendant. The judge is sensing a lack of structure and, honestly, a lack of remorse. She's giving him a massive wake-up call. 8 years hanging over his head. Transition. But if you think that was tense, wait until you see our next case. We're moving from a young man who doesn't have a plan to a woman whose life was torn apart by tragedy. But the court is struggling to balance empathy with the law.
I'm so sorry. I don't have his, this is the wrong trial court certification. Okay. So I need the other one from over there.
We'll get it, Judge.
Okay. All right. Oh, you can go ahead and get it. Thank you. All right, probation. This is what I'm going to do. Sentence him to 8 years in the prison, suspended and probated for 8 years. There's a $2,000 fine. That will be probated. Do you have any children?
No, ma'am.
Okay, that's a good thing. You're not ready. There's going to be regular reporting by Zoom or in person, regular random UAs, tests for levels, field visits 1 time per month until further notice. There's to be no contact with Ethan Durand. 200 hours of community service restitution. Those hours will be deemed satisfied if he obtains his GED or some type of trade school certification. The court will note that the restitution has been paid in full.
Judge, there was
Oh, there's some more restitution.
well, we left it that if there was less, it was okay, and but if it was happened to be more, that the victim would document with probation, and my client is willing to agree that if there was something else that he could pay a judge.
All right. Can I have a restitution hearing in 30 days, please? All right. State,
Yes.
by November 10th, let us know if there's any restitution.
And the attorney that's out, ADA, she was working on that, but she wasn't in court today to give us a response. She might already have that answer.
Okay.
She was calling in from court the last time we were in court, last Thursday.
Okay. Probation, is there anything else? Thank you. Proof of employment within 35 days. No employment as a home health care provider or with minors. And there's to be no residing with minors. Is there anything else you need to be successful?
No, Judge. Thank you, Judge.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I hope you do well on probation, because if you do not, you're looking at potentially 8 years in the prison. Do you understand? So if you're trying to make a decision, is this something I should do or not? If it's going to result in you having a motion to revoke, don't do it. If you think, oh, well, maybe, or maybe they'll catch me, maybe they won't catch me doing this, don't do it. Because your attorney will tell you, I take no pleasure in sending anyone to prison, but if it's warranted, I will. You understand?
Yes, ma'am.
Now, I don't know what's happening with your mom. I don't know why your mom allowed you to drop out at 10th grade. I don't know why your mom allows you to smoke marijuana at her wedding. I don't know what's going on in your household, but obviously you're going to have to be your best friend. And as your own best friend, you're supposed to want what's best for you. And what's best for you is to complete this probation and start using marijuana, because you don't know what's in it. And it's going to result in your being revoked. You understand?
Yes, ma'am.
All right. Good luck to you. Thank you.
Excuse you.
Yes. Good seeing you.
Same here.
Thank you.
You're welcome. Are you Miss Sandoval? You need to speak up.
Yes, sir.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Stephanie Sandoval who was placed on deferred adjudication in 2018 CR 12679 for the offense of assault peace officer judge on October 4th, 2019 for a period of 6 years? Is that you? Is that you? Yes or
Yes,
no?
sir.
State?
Yes, Your Honor. Violating condition number 5 in Bear County, Texas. Defendant Stephanie Sandoval did in there fail to report to the supervision officer as directed for the months of October, November, and December 2024 in violation of condition number 5.
All right. How do you plead to that? True or not true?
Yeah.
We'll waive the remaining violated condition.
No objection. No,
If you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
Just-
Do you?
and I apologize. I thought it was a third-degree felony that she was charged with.
No,
Second.
it's listed as a second.
It is.
All right. So did you understand that? Knowing that, do you still wish to plead true to violation of condition number 5? That's either yes or no. If you don't want to continue to go forward with this, then it will be set for a contested.
Hoping not.
No. I'm not here to figure out what your agreement is. My only question for you is, you've pled true to violation of condition number 5. Is that correct? All right. So Do you understand that I can revoke you, regardless of whatever agreement you reach with the state? I can revoke you and sentence you up to 20 years in prison. Do you understand?
Can I have just a moment, Judge?
Sure.
Just a minute.
Receive. But I'm going to let the deputies take you back because they can only have so many inmates in the box. But your time, whatever the correct time is, we're going to make sure you have it today, okay? All right, thank you. You're welcome. All right, we're back on the record in 2018, CR 12679. So my question to you is, you're entering a plea of true to violation of condition number 5?
Yes.
All right. Do you understand by entering true to violation of condition number 5, the court could find it true, grant the motion, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court is going to find violation of condition number 5 true. Is there a proposed agreement?
Yes, there is, Your Honor. It is to deny the motion to adjudicate, continue on the verb with the amended conditions of extended for 2 years. Also, a TAP evaluation while in custody, and a drug court evaluation. If she's not accepted, the state is recommending, I believe the text up might argue on this, if she's not accepted, therefore, safe.
And that's our understanding of what the state is recommending, Judge. I guess my understanding is we do have an agreement to extend and keep her on her probation or community supervision. We would just be asking for an intensive, monitored outpatient type situation with drug testing. And Judge, there's a lot that I'd like for you to consider.
Yes.
We can do it briefly if I could just
Sure.
swear my client in.
Oh, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes. Sir.
All right. State your name for the record.
Stephanie Sandoval.
All right, you may proceed.
Okay. Ms. Sandoval, you're aware that you've failed to report for multiple months on this community supervision, correct?
Yes, that's correct.
Okay. And can you tell us what happened in July of 2024?
The father of my child and love of my life fell in the accident, and we have a 3-year-old.
Okay. What kind of an accident was that?
A lady took her cancer pill for the first time and fell asleep at the wall. So he was ejected and he flatlined 3 times and had a heart attack.
Okay. And is his name Ricardo Arana?
Yes, sir.
Okay. And this is a copy of his obituary?
Okay.
And Judge, I've tendered this to the state if I could just proffer to the court.
Sure.
For your consideration.
You are counsel.
Thank you, Judge. Appreciate it.
Mm-hmm.
Okay. And did Mr. Arana provide child care to your daughter as well as yourself?
Yes.
Okay. And so once he was killed, essentially most of the burden fell on you. Is that correct?
Correct. My car was out of commission. I didn't have it. I was a stay-at-home mom for 3 years. My daughter was born in the medical condition. So once he was gone, I couldn't leave her at home alone because, obviously to go to the lab, you need somebody to care for your children because they're not allowed there.
Okay.
I'm not making excuses. It's my responsibility, but I couldn't leave her alone.
Okay. Have you historically had issues with alcohol?
Yes.
Okay.
And I'm not making excuses. My past transgressions. I just don't want to be her fault for her to lose both of her parents.
All right, so here's my question. Where is your child now? Who's taking care of the child? All right, so here's the problem the court has. One, I think inpatient treatment is the best for you because looking at the motion to revoke, I understand that you're only pleading to number 5, but I have all of these violations of condition number 2, and it's before the death of your husband using meth and amphetamines over and over, and then not submitting to drug testing over and over. So you have a choice. And let me just tell you what your choice is. I can revoke you. I'll sentence you to 3 years in the prison, or either you're staying in the custody. You're going to be referred to felony drug court. If felony drug court doesn't accept you, you're going to safety. Those are your only choices.
Could we present you I have some things regarding the drug use to present, if that's okay, Judge.
Sure, you
If I
can.
could ask her about that.
All right.
Thank you, Judge. Okay. And so there have been positive tests for amphetamine, correct?
Sure.
What mental health conditions do you struggle with?
I have ADHD.
This is a heartbreaking turn. Stephanie's husband was killed by a reckless driver, leaving her with a medical needs child and no support. Clarification. While the court has empathy for her tragedy, legally, her violations, using methamphetamines, started before her husband's death. This is a cold math of the courtroom. A tragedy doesn't erase prior criminal conduct. The judge is offering a choice: prison or a high-intensity drug court. Engagement question. In a situation like this, do you think the court should be more lenient because of her loss, or does the drug use make her more of a risk to her child?
She PTSD anxiety.
Okay. And were you taking Adderall?
Yes.
And you're aware that Adderall contains amphetamines?
Yes.
And admittedly, were there times where you took that without a prescription?
Yes.
Okay. But do you currently have a prescription for that?
Yes.
Okay. And I've tendered this to the state as well. Is this a copy of your current prescription?
Yes.
Copy this to the court as well. Okay. And is there anything else that you'd like for this judge to know about your motivations, your hope moving forward, and anything about your case?
Yes. I know that drug supervision and being drug tested is imperative as well as further support. I'm currently continuing doing an IOP, but also the Children's Specialty Court contacted me, and I really want to work with them to try to be unified with my child, which I will also be getting drug tested 3 times a week. Judge, I made some mistakes and so many mistakes in my life that have kept me from doing well.
And so regardless of what happens in this court, you're going to be drug tested 3 times a week. Is that correct?
Yes.
Okay.
All right. So this is what I'm going to do. You've been on this probation since 2019. You missed drug testing. You've been using Adderall, sometimes with a prescription, sometimes without a prescription. So you have 2 choices. I can send you to prison for 3 years, or either you're going to be referred to felony drug court. If felony drug court doesn't accept you, you're going to safety. If you're honest with felony drug court, what I can tell you is felony drug court will accept you. It's a difficult program. They will work hand in hand with the CPS court. Those are your only 2 choices. So what do you choose?
I want to try going to felony drug court so I could try to get my power back.
All right. So the court is going to deny the motion. Alternate amend conditions to the following in custody. There's to be a referral to felony drug court. If not accepted, then there's to be safety. And there's to be 160 sober meetings in 160 days upon release. No unsupervised contact with minors. And probation, is there anything else?
No, Your Honor.
Judge, needs to be extended.
Yes. Thank you. I knew I was thinking about that. Extend for 2 years.
And just to clarify, Judge, the no unsupervised contact with minors, does that apply to her daughter as well, or is
Yes.
that okay? Because I know that there's a CPS
Yeah, there's
thing going on.
visitation, and you were hoping to reunify within 6 months to a year.
Well, that visitation needs to be supervised, and usually that's what CPS does.
It is.
But if CPS eventually at some point were to modify it so that she could have custody, would this be modified as well, Judge?
Well, she'll need to come here. A motion will need to be filed. I'll hear it. And what I can tell you is during that hearing, they can appear by Zoom, but I'm going to need the caseworker and the children's attorney if there is a child's attorney.
Understood, Judge. Thank you.
All right. Thank you. Have a good one.
You too, Judge.
Okay, bye-bye. Are you all ready to proceed on the motion?
Yes, Judge.
Court is calling 2018 CR 12679 State versus Stephanie Sandoval. Can I have parties announced?
Jason Deerham for the state, Your Honor.
It's Fernando Cortez for Ms. Sandoval, Your Honor.
And are you Ms. Sandoval?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? And did you understand it?
Yes, ma'am.
Are you the same Stephanie Sandoval who was placed on deferred adjudication in 2018 CR 12679 for the offense of assault peace officer or judge on October 4th, 2019 for a period of 6 years and extended a total of 2 years?
Yes, ma'am.
All right, state.
Yes, Your Honor, violated condition number 22 on or about the 9th day of May 2025 in Bear County, Texas. The defendant, Stephanie Sandoval, did in there failed to participate in the felony drug court program as ordered by the court in violation of condition number 22.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated condition.
Any objections to the waivers?
No objection, Your Honor.
All right. Did you understand by pleading true to violation of condition number 22, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Judge.
Knowing that, do you still wish to plead true to violation of condition number 22?
Yes, ma'am.
Court will find violation of condition number 22 true. Is there a proposed agreement?
There's a proposed agreement that's not agreed to, Judge. The state's recommendation is to deny the motion, continue on deferred, and to have her attend safe.
And defense?
Which at the top evaluation is recommending ISF, also safety, but ISF, and also an intensive outpatient treatment is an option also based on the top evaluation. I believe that this individual is probably more related to alcohol. I would ask the court to put her on a scram unit, go ahead and allow her through her insurance to get the intensive outpatient treatment and continue. She would probably be done, she gets extended in October. She has a 3-year-old child also being cared for by the mother-in-law. This is a tragic case where her husband deceased during this probationary period and caused some serious trauma to this individual. I would just ask the court, she doesn't have any history of drugs or violence. She does have a DWI. That's why I'm suggesting a scram unit just to monitor the alcohol and see if I believe she's serious about this. If she is, it'll be found out very quickly. The scram unit going to know that she's drinking, anything like that. I think that's mostly the problem here.
But felony drug court was going to solve that problem, and she didn't want them to solve it.
She's probably rolling in her right head.
Yeah.
But I bet after 55 days in jail right now, it kind of does something to your brain. And
No, because see, here's the thing. People can't write their own programs. If people could write their own programs, you wouldn't be here. And you've been on this probation since 2018. There's nothing else for the court to help you with. I offered you to help. You don't want it. The help was felony drug court, and you didn't want it. So where we are now is the court is going to grant the motion, find you guilty, and revoke. Does anyone wish to speak to time?
We'll defer to the court, Judge.
Well, only I would ask the court to consider the ISF, Judge. That's a significant treatment. See how she does with that. It's something that the court can do that goes beyond felony drug court. This is more than that. And we're asking the court then to do more than that and give her the ISF.
Felony drug court is very intensive, and she could have been doing that out.
And here's the moment it all falls apart. Stephanie was given the outpatient lifeline via drug court, but she couldn't or wouldn't follow the rules. The judge's words are chilling. People can't write their own programs. If they could, you wouldn't be here. The grace period is over. We're looking at a 3-year prison sentence. It's a tragic reminder that even when the court wants to help you, you have to meet them halfway. Engagement question. Was 3 years too harsh? Or was a judge left with no other choice after multiple chances?
Patient. So the court is going to sentence you to 3 years in the prison, give you credit for any time served. The court will request the therapeutic community, and I'll retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Your Appeal with your attorney? Did you understand it?
No.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And your attorney will explain to you what it means that I'm keeping jurisdiction. All right. Thank you. Did you understand you're charged with assault, peace officer, or judge as a second-degree felony? Range punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right. It's my understanding he has to pay restitution up front. Has that already been done?
It has, Your Honor. There was a holdup this week.
That was the holdup. All right. Anything you want to say?
No.
I mean, well, you should say something because I don't have to follow this agreement. So why are you doing this?
Doing what? You're right.
Do you not know why you're here?
Yes, Your Honor.
So one, why are you smoking marijuana on private property? Why don't you leave private property when people tell you to leave and it's not your private property? Why would your family give you the okay for this? Why would some random girlfriend who says she's your girlfriend say leave him alone, and then she jumps in it trying to fight the police, and then your mom comes up and is sort of like okaying that?
Joshua Paul Rubin. He was on the iPhone. Maybe he's gone. No, he's not. He's here.
You have to unmute Mr. Gubin.
This is the city of Detroit versus Joshua Paul Gubin. Case number SP 1411448. Counts 1, 2, and 3. Appearance for the record, please.
Elwood F. Berry Jr. on behalf of the defendant. State your full name, Mr. Gubin.
Joshua Paul Gubin.
All right, one.
Your Honor, for purposes of arraignment, we would waive the reading of the information and stand mute.
And we'll enter a not guilty plea on his behalf. We'll give him a $0 bond. Hold on a second. No valid registration, never acquired plates, and no insurance misdemeanor. Do you have documentation for this vehicle, Mr. Gubin?
Yes, I do.
Where are they?
Here's the registration.
Hold up. Let's see what you have. This last pickup plan, Joshua 1/7/20. That's expired.
But it's still, I registered.
Almost the third month of.
Already sold the truck. Like it's sold, but I don't know. They took it first bought the truck. I got license plate right after.
Understand what you're saying? Say that again.
I had just bought the truck when I got ticketed, and I immediately got the truck registered and fully insured right after. But I sold the truck.
Do you have a vehicle in your name, sir? Now?
Yeah, I do.
Let's see what you have for that vehicle, registration and insurance.
Okay. I have my Progressive app.
You want to send me, you want to send it to my email address, sir?
Sure.
I'm gonna put my email address in the chat.
Okay.
I'm looking for valid registration and insurance, please. Let's pass the matter until Mr. Gubin gets those documentations to us. All right, let's go back on the record, Mr. Gubin. I have a insurance.
Top right corner. It's my wife and me.
Quiet, Mr. Gubin.
I have an insurance policy here. The only thing about this is I don't see a valid date.
Oh God, you cannot be serious. Do you not see the Ram truck right there?
I'm serious.
I'm surprised I'm not getting the same courtesy as the others. This is blowing.
I'm giving you the same courtesy. I'm giving
All
you an
I'm saying
opportunity to show me some proper documentation. You showed me some invalid registration first.
Sir, the truck is gone, sir. The truck is it got stolen from me at gunpoint. Insurance paid me off for the truck.
Okay.
That is not
The policy that you asked for, and you're not satisfied. And I showed you valid
Google,
proof
Mr.
that the
Google.
truck was
Mr.
registered.
Google, please.
Mr. Google. Don't say anything, Mr. Berry. Don't say anything, Mr. Berry. Mr. Google.
What did he say?
Mr. Google.
All I was trying to say was I'm extremely sick. I'm literally going up right now.
Listen to me. Listen to me. I'm not. We're not going to. We're not going to talk like this. I'm going to talk, and you're going to listen, and I'm going to give you an opportunity to talk. All right.
We wrap up with Mr. Goodman, who is currently teaching a masterclass in how not to talk to a judge. Accusing the bench of not giving you the same courtesy while providing expired documents and arguing through a Zoom screen is a bold strategy. Reaction: the judge's unbelievable bro face says it all. This is a high-stakes world of virtual court, where your attitude is just as visible as your evidence. Thanks for riding along on these legal roller coasters. Final question: which defendant was their own worst enemy today? Let me know in the comments. And don't forget to hit that subscribe button for more courtroom breakdowns.
So, first of all, don't accuse me of not giving you the same courtesy as everybody else. Because that's absolutely not true. I don't have to dismiss these cases. And just because you said you had insurance, I can send you straight to trial or make you or not make you take the deal. I can't make you do anything. But I'm trying to give you an opportunity to show me valid documentation, okay?
And I'm trying to.
And I don't see, what I told you is, I don't see a proper date on this insurance policy that you sent me.
All right, I'm going to show you this registration that I had on the Ram, and you will see what day that ticket was issued and what day this registration was issued, which was a month or two after the ticket. So the truck was registered and plated, fully insured after I received the tickets.
Just show me the insurance policy, the portion of the policy that has the expiration date. You showed me that registration. 1/7/2024.
So you're asking to see if what? A valid what?
I'm asking to see the date on the insurance policy. You gave me an insurance policy. I have that, but it has no date on it.
All I showed was proof that the truck was insured, registered.
All right, I'm not gonna deal with it. All right, let's set a trial date. Set a trial date.
I'm trying to get this dismissed. This is literally holding me back right now.
You get it dismissed on the date of trial. Date of trial.
Nice. Thanks for no, I see clear as day why I'm not getting the same courtesy. Your name is Sean Perkins? Yeah, okay. I will. Yeah. Okay, I get it.
Mr. Gubin.
I don't need to hear it. I don't need to hear the blabby blab. Just stop talking to me.
I was just gonna ask, did you want to go in a breakout room?
What is a breakout room? I showed all my proof. I showed all the proof. I showed the proof, Mr. Sean Perkins. What is it? Is it my, what is it? My complexion? It's my complexion, isn't it, buddy? Yeah, Mr. Uneducated Judge.
Have a good day, Mr. Goodman. You keep on.
How are you even a judge?
I'm gonna hold you in contempt, okay? And we're gonna give you some jail time, okay?
What a clown.
You done?
Anything else?
Are you
Anything
done?
else, pal?
All right. I'm gonna hold him in contempt. I'm gonna give him 30 days Wayne County Jail, all right?
Right, okay.
You have an absolute, you have an absolute right to a hearing.
You will experience a huge lawsuit. I showed you every single proof of documentation that I needed to, and you refused to dismiss my stuff. Well, why is that?
Have a great day. We're not talking anymore, all right? We're done talking. And who are you here on?
I am here on Joshua Gubin.
He has not showed. He needs, I told him to be here in person today, and he has not showed. You're not neither. Oh, I think he is here. He is here. Okay, so here's the deal. It's nothing really to talk about with Mr. Gubin. I told him to come in. I said I gave him 30-day Wayne County jail for contempt last year. Yeah, I see him hold up a child, and his child, he didn't come down. So again, he continues to defy orders of the court, and we just don't have much to talk about.
Well, Judge, I understand that that may be the court's position as it relates to this matter. May I have just 1 second? I apologize, Judge. I needed to plug my computer in. So I understand that may be the court's position. I just got retained on this matter this morning. I was not present at the hearing where you apparently held him in contempt. He obviously has an opportunity to prepare and present a defense to the allegation. I'm not sure if the court made a finding as to whether or not this was civil or criminal contempt, and further, whether the court actually determined whether it was direct or indirect contempt. Obviously, the court's ability to sanction an individual, especially with a deferred sanction, may be limited under these circumstances. So what I'd be asking the court to consider doing is giving me a brief adjournment so that I may obtain a copy of the transcript of the last hearing. And I would just cite to case law, which indicates that my client does have the ability to obtain an accurate transcript of the hearing as a matter of due process. And when we come back, I will be prepared to effectively, properly address this matter.
Well, the contempt was the contempt was right on the record on the record, and I do have you can get the record for that. It was I did hold him in criminal contempt. That's why I told him 30 days Wayne County jail. And from my understanding of the court rules, he had his opportunity to contest that. That ship has long sailed, from my understanding of the court rules, because this was done over a year ago. And the only reason that Mr. Gubin come back before me is because he got some other cases. He let the tickets go on the warrant status. He only is before me because he got the other cases. So I still need his presence here. I'm going to readjust his bond now.
Well, Your Honor.
So he continued. I'll let you speak, Counselor, and I'll let you do what you need to do as far as your job. But I'm going to do my job. And Mr. Gubin continues to defy the court's orders. And we'll talk about bond right now. City of Detroit versus Joshua Gubin. Case numbers SP 141144. Count 1 and count 2. SP 1669671. Appearing for the record, please.
Yes, good morning, Camilla Barkovic, appearing on behalf of the defendant who is present.
Your Honor, Rami Hijazi, P82830.
You can make the record now as far as what you want to do, either counsels if you want to, as far as Mr. Gubin is concerned. We'll call the date and time. There's 2 warrants out for Mr. Gubin's arrest. Let me see what the action was the last time. Mr. Hijazi was here last week when I when he appeared on Mr. Gubin's behalf after Mr. Gubin showed up, and I realized that he was the gentleman that was just very, very contemptuous on that day that he was here last year. The allegations were made on December the 7th, 2022. Mr. Gubin was arraigned on those matters on February 29th, 2024. There was a show cause scheduled for August the 15th, 2023. And the register of action can reflect all the other necessary court dates that were had. But Mr. Gubin has shown that he does not comply with the court's orders as far as appearing before the court. Mr. Gubin has shown that he is very, very contemptuous. This is not something that I have done except for one other time. And Mr. Gubin, I gave him a week from last week to get his affairs in order to turn himself in, and he's still not here. Go ahead and make record and speak to bond.
Thank you, Judge. I've already articulated some of this to the court off the record, but I was just retained to represent Mr. Gubin in this matter this morning. I am asking for an adjournment of today's hearing so that I may obtain a copy of the transcript of the hearing that was held where you apparently held Mr. Gubin in contempt. He does have a right to counsel in any contempt situation. In addition, he does have a due process right to obtain an accurate transcript of the hearing. I would like to obviously obtain all relevant information and then address this matter appropriately. I'm asking that you take no action today and give me the opportunity that I am requesting on behalf of my client. And if you'd like me to transition into the bond issue, I am happy to do that as well.
I'll let you go ahead with bond.
Thank you. Your Honor, it is my understanding that mere traffic matters are pending before the court, at least one civil infraction, and I believe a no insurance misdemeanor. These incidents date back to 2022 based on my review of the Register of Actions. He has appeared in connection with this matter, which the court has noted. Apparently, he was here last week, and you may have recognized him. But the point of the matter is, I've known Mr. Gubin for a while. He always appears as required and as instructed. I understand that the court may have a difference of opinion as it relates to that, but I would attest to that. He is a lifelong Michigan resident. He has extremely strong family support. He is a father. He has minor children, actually, one of which is visible on the Zoom as we currently sit here. He owns his own business in Wayne County and operates that business very successfully. I think when you consider factors that are relevant to a bond inquiry and are not relevant to collateral matters such as prior actions engaged in allegedly before the court, personal bond is warranted, and it's my understanding that that is what may have been previously entered in connection with this case. Upon conviction of the only misdemeanor with which he presently stands charged, his maximum sentencing exposure is minimal. He is obviously presumed innocent at this point in time. And for all of those reasons, Judge, in addition to other reasons, such as his lack of any significant or substantial criminal history, which is a factor that the court shall consider when it sets bond, I believe a personal is warranted. And retaliation for what allegedly occurred in the past should not impact bond under any circumstance.
All right. Well, bond is going to be set at $2,500 cash. I still, the order of Mr. Gubin still showing up because despite what you articulated on the record, Ms. BACKFIRES, I have, we put the warrant out for Mr. Gubin's arrest a long time ago. He was supposed to be in person here today. He's not. He also has an assault and battery case that he has a warrant out for his arrest for as well. So he showed the court and demonstrated to the court he has not only with this court but with the other court, courts and other judges in this courthouse that he has a failure to appear or something. So $500 cash, and it's still ordered that Mr. Rubin show up in person to the court for the conviction hearing, and we will address and you can appeal the matter to a higher authority if that's what your client chooses to do.
Your Honor, I have a comment as it relates to a cash bond. I'm asking that the court impose a cash or surety bond. My interpretation of the court rules as it relates to bond and statutory authority allow the defendant to elect whether he posts a surety or posts a cash bond. And my position is the court cannot outright prohibit a surety. So I'd ask for the addition of a surety provision.
The court has made his ruling, Counselor. You can take it to a higher authority.
Thank you.
Thank you. All right, who's next? Detroit versus Joshua.
Yes, good morning, Camilla Barkovic, P78254, appearing on behalf of Mr. Joshua Rubin, who is present.
Good morning, Mrs. Rubin. State your name and the record, please. Good morning, Joshua Rubin. I did the date and time set for a pre-trial. I do have an offer here, which is pleading responsible to.
The camera, no camera.
Hold on, Mr. Grant. It's pleading responsible to the amended count of limited access 1 to 5 for the speeding, and as charged, I'm thinking of the improper equipment.
That is correct, Judge.
And then other matters are to be dismissed. Is that correct?
That's accurate.
You want to take the deal, Mr. Goulden?
Yes, Your Honor.
Will you stipulate on behalf of your client in the basis of the ticket as an accurate factual basis for that responsible plea in the client's behalf?
Yes, Judge, I will.
Stipulate the probable cause for the dismissal of the other matters.
Yes, Your Honor.
I'm going to find your client responsible for the amended count of limited access 1 to 5 for the speeding based on that stipulation, and as charged to the improper equipment.
Thank you.
There'll be $125 for the limited access 1 to 5, and $120 for the speeding ticket all the way to the warrant fees.
Thank you, Judge.
And he'll pay any reinstatement fees, which I don't see. Anything further? We're going to take them into custody.
Well, Judge, I wanted to ask that you respectfully reconsider your position. I reviewed the record of the hearing in question. I understand that my client's conduct may have been considered disruptive and disrespectful by the court. A lot of time has passed since that occurred. That's no justification. But I think it's important for you to know the circumstances under which his actions occurred. So unfortunately, my client was suffering from the flu extremely bad that day. He remained on Zoom for an extended period of time. I'll even attest, I have sat on Zoom for an extended period of time, and oftentimes it becomes extremely frustrating. Obviously, this court moves its docket. This court is very accommodating. But given his illness and given the circumstances, he was not a happy camper. Again, that is no excuse for his actions towards the court. You obviously don't know Mr. Gubin. You probably never will. I've known him for an extended period of time. He is not who this court may think he is. He has always been respectful, diligent in addressing all of his obligations. He's 27 years old. He does not have any significant or substantial criminal history. He's married. He has 2 minor children who are absolutely beautiful. His pride and joy. He owns and operates his own business in Wayne County, specifically a gas station. His wife doesn't work. He's the sole provider for his family. Judge, if you would consider not imposing a jail sentence at this time, and maybe imposing an alternate sanction, which the court has authority to do, such as a fine, or anything else that this court deems appropriate, such as community service, my client will gladly accept that. I do know that he wishes to make his statement directly to this court, and I'll allow him to do that at the present time if the court would permit.
Well, let me say this. I appreciate your argument and your diligence on the behalf of your client. I went over and I reviewed I thought I exercised the utmost restraint in the blatant disrespect that Mr. Hoover. And let's go back to your about the Zoom. There's always an opportunity for an individual to come in person and sit in.
Sure.
So that's sort of like, the court looks at that as sort of like a benefit. You know, we allow people at work, we allow people at home who are sick. I didn't know he was sick until he mentioned something about being sick in the middle of,
absolutely,
the end of what, but that's of no consequence of the court. I really don't care about him being sick. His obligation, he could have said, I'm sick and can we pass this on? But it was every attempt that the court tries to offer individuals an opportunity to show documentation, which the court doesn't have to do that.
I know.
If he didn't have proper documentation at the time to stop, the court doesn't have to take that extent in dismissing the case because it's bringing proper documentation now. It is the court's view of Mr. Gubin's actions is that Mr. Gubin was trying to deceive and perpetrate fraud. Mr. Gubin was given multiple times showing proper documentation. And we take it and we look at it on the screen. So he doesn't have to email it. He doesn't have to send it. He sends the first document. It wasn't valid. I said, Mr. Gubin, he indicated to the court that at first he indicated he got the truck, but he sold the truck. That was his first argument about what happened to the document. I said, do you have a truck? Do you have a valid document in your name now? He says, yes, I do. Then he emails the court the document, which I'll find in the record and put it in the file. He emails the court a document that shows me this debt sheet of insurance, but that insurance never had a date on it. So I addressed that with Mr. Gubin. And this is all in the record. And I asked him, hey, this doesn't have a date. Then he proceeds to show me another document that doesn't have his name on it. Anything, and when we brought that up, and then that's when things went further down the hill. So I don't think Mr. Gubin's actions had anything to do with him being sick that day. I don't know whether he was sick or not. And again, I don't care at this point whether he was sick or not. I tried to exercise every bit of restraint. Then he further argues with the court and tells me, while he's swearing, that the truck was stolen at gunpoint. That was his other argument. First he says he sold it, then he says it's stolen at gunpoint. Then Ms. Harris tried to step in and try to mediate the thing and calm the situation down. Mr. Gubin was not trying to hear that. And then Mr. Gubin goes all the way and puts race into the argument that it's because his complexion that I am the way I am, and I'm doing him the way he felt I was doing him, which was absolutely not the case. And I still was exercising restraint and not doing anything. He calls me uneducated. He starts to throw names and things like that. So that's why we're here. We're there. Then there's going to be a huge lawsuit. So that's why we're here. Furthermore, this happened in February of 2024. February 29th of 2024. Mr. Gubin had ample opportunity to come to the court and try and rectify or bring it in. Mr. Gubin knew the court imposed a contempt sanction on him before he left the court, and he never did. The only reason he's back in here now is because he got more tickets. I told him to show up in person multiple times before he hired you, Ms. Barkovich, and he disobeyed the court's order. So at this point, the only sanction that I think is going to get to Mr. Gubin is a term of jail.
Your Honor, may I respond to some of your commentary? I'm not here to quibble with you, but that was something I needed to discuss with Mr. Gubin once I actually became privy to the transcript, the inconsistencies with his representations to the court. I will tell you that I have received information that both statements he made to the court with respect to the vehicle were in fact allegedly true, in the sense that his vehicle was stolen. He apparently has a police report depicting that it in fact was stolen under the circumstances he represented. The vehicle was allegedly then recovered, returned to him, and then he subsequently sold it. So I can understand why the court thinks he attempted to perpetrate a fraud because he advanced seemingly inconsistent statements. But it is my understanding that he has documentation to back both of those points up. I'm not sure if that makes a difference to this court, but if it does, I'd ask for an opportunity to present that to the court. I understand my client made some statements which should not have been made, and he'll acknowledge that. I didn't advance his illness as an excuse, but I mean, we all know as human beings, any time we are not feeling well, we become more jumpy or, less tolerable. So he apologizes sincerely. He has remedied all issues as it relates to his license. He actually has a valid driver's license at the present time. His car is insured, it's registered. I understand that you think a jail sentence is an appropriate sanction. If you are insistent on continuing to maintain that position, which you can do because you're the boss here, Judge, I ask that you consider a reduced sanction and give him a
I'll heard the argument. Y'all let your client speak. If he chooses to, you don't have to. You don't want to.
You would like to, Judge.
I just want to start off with an apology. I apologize for my actions. They were totally uncalled for that day. And I made some terrible misjudgments.